Let's begin this week with the continued controversy around the school funding amendment as the debate continues to heat up ahead of the vote in November. Last week, Pulaski County Schools posted images advocating people to vote no on Amendment 2. Many people in favor of the amendment argue the school broke the law. Meanwhile, many people opposed say the district's leaders were exercising their First Amendment rights. The Attorney General's office told lawmakers Thursday where advocates can draw the line.
It creates, at least in the minds of the public, a question of, is this the assertion of personal opinions, or is this an institutional position taken by the school? And we don't want our schools to be seen as taking partisan positions.
The AG's general counsel argues the law does not limit First Amendment rights to take a position as long as it is in the appropriate setting. For example, he says discussing the amendment openly at a school board meeting would be appropriate. Representative Maddox, I want to begin the conversation with you here. How should people in education settings be discussing this amendment?
As a staunch advocate for our First Amendment rights, it is very important to me that our educators have the broadest possible latitude to speak on these sorts of issues, on any issue. However, to me, the line is drawn very clear when it comes to using taxpayer resources or any type of equipment in order to put out a political message advocating against a ballot initiative. To me, the line is clear that that's not an appropriate use.
Representative Brown, you see it the same way?
My question would be whether it is it political. It's an issue that dates to or deals with what is right for a community. And in Pulaski County, they chose to move forward to make that happen, to get information out to the people. The unfortunate thing is that a lot with this amendment and with other amendments, the information does not get to the grassroots. It gets to the people that are going to make the decision. And this is a generational or even a centennial decision based on what's going to happen in Kentucky as a result of this vote.
One question that was brought up in the committee by Senator Cassie Chambers Armstrong out of Louisville is, how do you draw the line between advocacy versus just general inquiries that may be made by parents in school districts, especially if you are talking about much smaller school districts where the line may be a bit muddled? You may go to church with the superintendent or principal or whomever. Any thoughts there?
I think that people have the right to get the information, and the information in this case is not out there. In my opinion, the language in the amendment says, "Are you in favor of school choice?" And it does not talk about how the funding for public schools could be affected.
Providing information, to me, is one thing, particularly in the context of a public forum or something of that nature. However, it is very clear that advocating vote no on Amendment 2 is political in nature, and also it comes down to whether or not you're on the clock, whether or not you're using taxpayer resources, whether it is the time that you are being paid for, or whether it is the social media presence that you are speaking on behalf of a public school system. That is where the line is drawn. It was saying to vote no on the amendment, and it was using public resources.
What should happen if the line is crossed? We heard at least a warning from the Attorney General's office, but it's a long time between now and November.
I think that the Attorney General's office acted wisely because they set the standard, and I'm hopeful moving forward that other school systems or anyone that had been considering using any type of public resources to advocate one way or the other on this constitutional amendment, that they would not do so. And that goes for whether you are for it or whether you're against it, whether you're a Republican, whether you're a Democrat. We should not be using taxpayer resources to engage in politics in that regard.
I disagree. I think that the message has been out there and put out there from the powers that be and from political positions and from party politics as to the constitutional amendment and what it means for Kentucky and what it means for public schools.
So where does the line get drawn then in regards to the 2021 law that's being referenced there, where these public dollars are not supposed to be used to advocate for or against?
That's more of a legal question. My position is one that's emotional, and it's emotional dealing with people in the Commonwealth, because I think that people ultimately will not understand until it happens. And the thing that I've been saying to my constituents is that there will not be a do-over on November 6th.
If a school district does have to come to a courtroom over this prior to November, could that affect how people end up voting in this or turnout on either side particularly?
I don't think that anyone wants to see a scenario in which additional taxpayer dollars are spent in litigation. That said, statutorily, this is quite clear that they are not permitted to use taxpayer resources to advocate for or against this amendment. So hopefully we won't get into a position like that.
Representative Brown?
Well, I think that we can get out into the minutia and we can talk about what's right or wrong and what's legal and what's illegal. I think this matter is so important because the Constitution of the Commonwealth of Kentucky has held that it is a right for there to be funds allocated for a common/public education for our state. So people need to understand clearly what that means.
All right, we'll have to leave it right there.